A very good evening, ladies and gentlemen. Welcome back to yet another Sundays with Online Dentistry. We are extremely happy to see you all here. Kindly wait for just a few minutes while we enter all our participants. Your patience is appreciated. Kindly wait for just a few minutes while we enter all our participants. Meanwhile, here's a glimpse of the history of online dentistry that we would like to share with you all. Thank you all. Our motto is to redefine dental education and take it to another level. Our numbers and statistics suggest that this firm was established way back in 2008. The total number of offline courses that are conducted are 123. And those who have missed the classes, we have more lined up classes for you all. The total number of online courses that are conducted are more than 600. We can proudly say that we are a very happy family of 30,000 people all over the globe. Well, all this was possible because of through these two great gentlemen. The first is Dr. Joby Peter, MDS, Professor and Head of the Department of Pediatric and Preventive Dentistry, Anno Dental College, Kerala, Head of Academics, Online Dentistry. And Dr. Binoti Abraham, sir, Kerala Dental Clinic, Alua, CEO, Online Dentistry. Well, online dentistry has finally gone offline due to after the COVID restrictions have been lifted. The next public demand course that is being held in December in Bangalore is Clinical Dentofacial Orthopedics. This program is being conducted on great public demand after a successful session of 2 days in Alua. This covers face masks, chin cups, and whatnot. All the aspects of orthopedics will be covered in this particular course. So if you want to connect to us, please do let us know. The next is interceptive and myofunctional orthodontics. This is a program that we are kickstarting our year 2022 with. This program is a 3-day myofunctional program that you would not like to miss. It covers all the aspects of interceptive and myofunctional orthodontics. So do not miss this particular program. In order to get in touch with us, kindly message us on these two numbers or log into our website www.onlinedentistry.in. Well, cutting to the chase for what we are here for, medical legal cases in dental practice. We all need to protect ourselves from the medical suits, from the lawsuits that are there. But half of us, or even a lot of us, do not know how to do it. Well, we have a great person with us here, Dr. L.B. Peter, sir. Sir, it's my honor to be introducing you on this particular platform. Dr. L.B. Peter, sir, MDS, PhD, PG Diploma in Clinical Research, LLB, M.Ortho RCPS, M.Orth RCS, and DIBO. Sir has a long list of achievements from a very tender age. Sir is a gold medalist in his BDS. Sir is a first rank holder in MDS entrance in MCODS Manipal. Sir has also held first rank in Kerala PSC examination for the government job. And also, Sir is indeed a man of firsts in first rank in his LLB examination. Sir currently works as a professor in the Department of Orthodontics in Government Dental College, Kottayam. Sir has a long experience of 22 in the clinicals and in academics. Sir has a lot of memberships and associations with a lot of Society of Indian Orthodontic Society and World Federation of Orthodontics. Sir has more than 30 publications to his credit, out of which 25 are international. Sir has also authored 3 chapters in a few textbooks. Sir's clinical interests include mini implants, biomechanics, edgewise appliances, legal issues in clinical practice that we are all here for today, psychosocial issues related to malocclusion, and also class 2 malocclusion. Sir, it's my honor and my privilege to be introducing you to this platform. Thank you for choosing us as your host. Ladies and gentlemen, Dr. L.B. Peter, sir, on your screens.
Thank you, Dr. Devika. Shall we start, Dr. Joby, or shall we wait for some more time?
We can start.
All right. A warm good afternoon, good evening to one and all, dear friends. Thank you, Dr. Devika, for the introduction. Thank you very much, Dr. Binu, Dr. Joby, Dr. Joe, for giving me an opportunity. Today, I sit before you in this webinar as a legal specialist, not basically as an orthodontist anyway. And let me go ahead with my presentation. My presentation is titled Legal Issues in Dental Practice, a case-based analysis. Now, most of you might have witnessed many webinars conducted by Dr. Binu and Dr. Joby, mostly on clinically related topics, with a lot of illustrations, demonstrations, hands-on sessions, etc. But now, today, they have decided to take a road which is less traveled. So we are on an unknown terrain today. Now I will explain this. Let me first differentiate between a legal presentation and a dental presentation that you have been witnessing for a few years. As BDS students, we have studied anatomy, physiology, biochemistry, pathology, microbiology, ortho, perio, etc. And we have undergone extensive sessions of preclinical and clinical training. A legal student also studies Indian Constitution, evidence, criminal procedure, civil procedure code, cyber laws, income tax, motor vehicles act, etc. They also undergo sessions in drafting and pleading, moot court, court visit, something very much comparable between the both professions. But the difference is, you open a dental textbook, you will see a lot of diagrams, demonstrations, illustrations, pictures, etc. And you open a law textbook, you will find volumes and volumes of written materials, legal theories, jurisprudence. So I hope you understood what I mean. The topic is dry. Law inside, please bear with me. Yes. Let me come to my presentation proper. This presentation is titled as a case-based analysis regarding legal issues. So I will be presenting certain cases and we will be discussing certain aspects related to that. My first scenario is a 12-year-old female pediatric patient. She was treated for restorative procedure. Parents were waiting in the waiting room. The next day after treatment, the parents claim misbehavior to the child against the dentist and creates a scene with the help of local politicians and threatens the doctor. Now, to my knowledge, there are 2 or 3 instances which I directly know where this incident has happened. There are even published incidents also. My second case would be a 52-year-old otherwise healthy patient underwent FPD treatment, suddenly developed cardiac arrest on the dental chair. Doctor tried to revive and suddenly transfers the patient to the hospital, but could not save. Relatives threatened the doctor and lodges a complaint in the police station. Now, there are enough literature which describes about death happening in dental chair, and a lot of newspaper reports also have come, and many cases have even gone to court. The third scenario is a 22-year-old male patient underwent orthodontic treatment for class 2 malocclusion with extractions. Few years later, patient reports back and complains of relapse and threatens to go to the court. Now, this is a case where I personally appeared before court as an independent expert witness. My fourth scenario or case is 35-year-old female patient developed pain following root canal treatment. She went to another clinic where they told that this teeth could not be saved with an RCT, and it would have been better if this teeth undergoes extraction. And the patient underwent extraction there. 2 days later, her husband reports to the first doctor and asks for a refund. Many of you might have come across this situation, especially if you are a practitioner. I at least know 2 or 3 situations, and this scenario is derived from a recent incident that happened in with a very close friend of mine. There are reported cases also in literature. And my final scenario will be during endodontic procedure, an endodontic file slips into the throat and patient aspirates it. It goes to the lungs. Patient was transferred to the hospital and was retrieved using an endoscopic procedure. Patient later claims negligence. There are enough and more case reports and case series reported related to this. In the institution that I am working, recently there was an instance similar to this. So these are the 5 case scenarios that I wanted to discuss today and the legal aspects surrounding it. Now, let me ask this question. What does all these cases indicate? First, the patients, don't consider you anymore as God. So stop playing God. Patients have become responsive, that is patient activism. Use of political, social, and social media by patients to their benefit. Need for extreme care while treatment, and the importance of proper records, communication skills, and informed consent during treatment. Need to update your knowledge and skills. Also, you should be aware of the laws of the land where you are practicing dentistry. This also highlights the importance of your social and political connections as well. So these are the points that I thought from analyzing the case situations. Now we will discuss if any further points towards the end. Let me come squarely to the case. The first scenario was 12-year-old female pediatric patient was treated and later they claimed misbehavior. Now let us analyze this. I thought this case will be discussed under these following headings. Why parents were waiting outside? Was there a real misbehavior that happened? Regarding creating a scene in the dental clinic, the involvement of local politicians, threatening, and the role of police in our clinical practice. Let me take the first question. Why parents were waiting outside? Now, in this instance case, which I know, which I have taken for a case scenario, the parents were offered a seat inside the operatory, but they, however, wanted to sit outside, stating that they were scared of blood. That was the real reason why patients sat outside. Now, that is fine, absolutely fine, no problem. But when they take this case later to court as misbehavior and all, as a legal expert, definitely I will think in this way. Was it pre-planned or is it a professional rivalry? Recently, a case happened in Kerala, which I know, which exactly somewhat like this, but it was due to a professional rivalry. So my advice regarding practitioners is, for all underage patients below 18 years, allow one bystander to be seated inside the operatory, and also ensure that you have a female assistant if you are a male doctor treating a female patient. The second question that I pose for this case is, was there a real misbehavior? Now, this also cannot be ruled out. We need to analyze the case from a neutral standpoint. If there was a real misbehavior, it is a serious offense. It comes under a category called a POCSO case, Protection of Children Against Sexual Offense 2012 Act. It is also a violation of Code of Conduct 2014. Now, under this POCSO Act, remember, most of the sections are non-bailable offenses. So if there was a real misbehavior, definitely this act will be introduced. But what really happened in this case was the doctor firmly instructed the patient to keep the mouth open. After a while of treating the patient, the doctor became slightly restless maybe. So he firmly instructed the patient to keep mouth open. That is exactly what happened. But the patient misunderstood it for misbehavior. Maybe because the child might not have even scolded by their parent, or maybe due to excessive pampering, which we don't know. But you can definitely justify this case by the child management techniques that are practiced in pediatric dentistry, like home restraining devices and all. So we need not worry about it too much. Now, my request will be to practice accepted and age appropriate methods in pediatric dentistry. Now, court believes only on evidence. You can get out of this case very easily if you have a solid evidence. How do we get that? CCTV inside your operatory speaks the truth. And this instance, this doctor really escaped because of the CCTV footage. My third question regarding this case is creating a scene. Now, it has become a fashion, or it has become very rampant, that doctors are being attacked, hospitals are being attacked. Remember, sometimes the patients may even go live also. So we have to be very extremely careful. Now, in an instance, if such instance happens, please don't get into arguments. You should understand the mob psychology. Mob will be very much violent, and they will do anything when they are in a crowd. So understand that, and please keep silence is golden, or please don't try to talk too much. Try to speak to a reputable person in private if possible. And also, if this unfortunate incident happens in the clinical practice, try to cancel some appointments until the scene is calm, because you will be under an adrenaline rush. So your treatment for the next patient also may be compromised. Also, you should be aware about the laws regarding crowd attack and hospitals. You can display this also in the clinic regarding those laws and the punishments. Keep some phone numbers handy. And here again, your CCTV inside the operatory as well as the lobby, and the patient's witnessing will speak the truth for you. Now, there are severe or good laws, strong laws, which protect you from your mob attack in your practice. But remember, these laws are basically against a minority group, that is doctors who doesn't have much bargaining power. So the strong law, which even gives punishment for 7-year jail imprisonment, is in fact weak in hospital attacks. That is a sad fact that we have to accept. Regarding the local politicians' involvement, remember, they will definitely come into picture for a political mileage. You also can have your allies. And see, maintaining a political relationship, of course, is not at all a problem, but involving them in such a scenario, my personal opinion is not good, because maintaining politicians are very expensive and a headache. Also, when you call them for a help, remember, they might reside in your office also. So this is my personal opinion. Please, you can take it with a pinch of salt. Now, regarding threatening, it is an offense. You can record. Now, you can sensitize your paramedics or your supportive staff to get into recording or all those things during that event. Regarding role of police, my advice would be to maintain a good relation with the neighboring police station where you practice. And you don't bother about arrest of a doctor, because arrest of a doctor should have to comply with certain procedures. I will discuss this point little later. Now, there are two backgrounds in which doctors can be arrested. One is due to negligence. Now, due to negligence, remember, these procedures are to be complied. But if it is because of a misbehavior with POCSO Act and all, then again, now a doctor can be arrested if the police officer is convinced with the evidence. So here our evidence plays most important role. So these are the points that I wanted to discuss regarding this case. Now, before coming to the final points, final analysis of this case, I just want to enlighten a little bit regarding the patient-doctor relationship in this changed scenario. We know that doctors are considered as God in India, especially, and we or doctors considered patients as their own family members. And the medical profession was considered as noble, and the power of healing is divine. Now, over the years, because of globalization, consumerism creeped into both doctors and patients. And the effect is effect can be noted as like, they have defined themselves, or patients have defined themselves as consumers, and they have defined doctors as service providers. I would say mere service providers. And the treatment that we do are defined as service, and our inability to make them happy or cure them is being defined as deficiency in service. Now, these points are defined in none other than, or nowhere other than, the Consumer Protection Act. Patients have become impatient. They are demanding, they are started thinking, is it value for money for any form of treatment that you deliver? And also, over the years, there has been a concept called deep pocket theory, which has deeply percolated into every aspect of life, which simply means that let the affordable one pay. Now, you just imagine a condition. Your car has been parked on the right side of the road where parking is allowed. A bike guy negligently come and hit your car. There will be a mob or a crowd coming, and I am telling you, definitely they will loot money from you. In the sense, they will make you pay for the negligent bike guy. This is because of the deep pocket theory. Now, this has percolated deep, and it has gone even to court also, where courts in various verdicts, we can see that hospitals are rich enough, so let them pay to the poor consumer. That attitude has been taken. And over the years, the skill acquisition has gone down. Now, let me ask you this question. Why dentistry is called as a profession? We know profession is a job or a skilled job or a vocation where a person undergoes a long duration of training, and the reward that the patient gets cannot be clearly defined in terms of money. So there are 4 requirements for a job or a vocation to be called as a profession. There should be an act to govern. We have the Dentist Act 1948. There should be formal training. We have BDS and MDS. There should be a council, in which a register is being maintained. We have the Dental Council of India or State Dental Council, and each professional's name has been entered there. And there should be a code of conduct in force, which the doctors need to obey. So these are the 4 requirements. So friends, my take here is, don't play God. Let us be truly professional and let us act as a truly professional manner. So my final thoughts or analysis regarding this case is, this is a very rare event, okay? Don't bother too much. But to my knowledge, I said there are 2 or 3 instances I know which has happened. Obviously, prevention is better. And if possible, because of this type of case, you can think of settling this case also out of the way. Now, evidence is the key. Ensure that you have sufficient evidence. Remember, the evidence that is given by your assistants or paramedics will not be viewed very seriously by court because they are paid by you. So a CCTV or such kind of unbiased evidence would be ideal. Now, you don't get panic, if at all, very rarely, but if at all you get involved in this, discuss the matter with a lawyer and a trusted colleague. Also insist on the victim's statement, as well as you insist the officers to subject the individual to an immediate medical examination, because that will help you whether any kind of malhappening or any abuse has taken place or not. And finally, most importantly, remember this POCSO Act is very strong, and Section 22 prescribes punishment for false complaints, and it can award 6 months imprisonment to the complainant who is giving a false complaint. So if you are very confident and if you have solid evidence, don't agree to withdraw case and things like that. You can straight away go ahead. But choice is, of course, you discuss, your lawyer will definitely help you out. So this is not at all a difficult case to handle. Don't bother too much, and we can easily get out of it. Friends, let me move on to the second scenario. A 52-year-old, otherwise healthy patient underwent cardiac arrest on the chair, and patient could not be saved even by taking to the hospital. The points that I thought we will discuss is regarding medical history, emergency drugs and all those things, hospital tie-up, ambulance and emergency number, criminal liability of doctors, and some awareness about medico-legal cases. I don't think I need to elaborate on the importance of medical history, emergency drugs, etc. Don't underestimate its importance. Use standard self-reported format in addition to your query in the operatory. You can circulate this kind of forms when the patient is waiting outside, especially if the patient is a newcomer. Remember, lack of emergency drugs and inability to use them amounts to negligence. And please look tomorrow itself about the expiry dates of the drugs that you have stored in your clinic. Please get trained regarding the BLS and other emergency procedures. To also train your supporting staff, and you can display the certificates in your clinic. The most important point is all emergencies are not negligence, so don't worry about it. But inability to handle an emergency may amount to negligence. So please train yourself and be able to handle emergencies in our dental office. Now, regarding a hospital tie-up, ambulance and emergency number, please understand, most of the time we are under-trained and under-equipped to handle emergencies. So you keep some ambulance number ready. And if there is a delay in such an instance, please ensure that you only take the patient to the hospital and ensure that you are with them, supportive for them, okay? And maintain a professional relationship with the emergency department of the nearby hospital. And also please have a physician or a surgeon in your contact list for some emergency contact. Now, let me discuss the third point, that is criminal liability. Now, criminal liability of a doctor, see, we don't have to worry too much about it, because for a doctor to be arrested or to fix a criminal liability, there is a precondition to be fulfilled. That is nothing but the legal word mens rea. Mens rea means criminal intention. That means the police officer or somebody has to prove that this doctor had a criminal intention and he acted accordingly, and that is why this incident has happened. Unless it is proved, a doctor cannot be arrested. Now, this case you should please note, Jacob Matthew versus State of Punjab. This Dr. Jacob Matthew was a surgeon in CMC Ludhiana. He was arrested for the death of a terminally ill old age patient. And finally, the court has given the final verdict stated that doctors are part of a noble profession and doing an essential job. They cannot be arbitrarily and simply arrested. And it has put forth certain guidelines. And one of the most important guideline is the case should be examined by a medical board, and the medical board should fix liability for a doctor before a doctor should be arrested. So based on negligence, simply a doctor cannot be arrested. But remember, police may summon you to the station. That is quite natural. Please attend them, visit them station with a trusted colleague or a lawyer if needed. Be very polite, and remember, don't leave any crucial evidence in the police station. You can explain to them and all fine, because a case cannot be settled in a police station. Now let us see the final point, awareness about medico-legal cases. We all know that now dentist can certify death, but this doesn't mean that when a death happens in a dental chair or in the process of transmitting it to the hospital, we cannot certify. This is only when a patient is under an oral surgeon's or a dentist care in the hospital. It is admitted, and subsequently, if the death occurs, the doctor can certify. Now, if such an incident occurs to our knowledge, please, you have a duty to intimate to the nearby police station. Not only this, in our routine practice also, if we encounter cases where you see some unusual injury or some kind of abrasions on the patient's body, and you suspect something medico-legal, you have a duty bound to inform to the police, and for that you have to maintain a wound register even in a normal clinic also, and all the details like the size, location of the wound, etc. should be registered in the wound register. Now, before going to the final analysis of the second case, let me elaborate some point about liabilities of a doctor. How does a doctor develop liability? A doctor develops liabilities based on law or statute. That is why it is called statutory liability. Now, the first statutory liability I wanted to highlight is contractual liability. Contractual liability is based on the Indian Contract Act. Now, you might think, is the relation between a doctor and a patient is a contract? Now, I will explain this little later. So first liability is a contractual liability. The second liability is tortious liability. This is based on a law called law of tort. Tort simply means a twisted thing. Now, in many countries, the law of tort is codified like IPC, Civil Procedure Code, etc. But in India, the law of tort is not codified. One of the tort is called a negligence. So if there is a negligence, it is a tortious act and it comes under law of tort. That means there is something called tortious liability for a doctor. The third liability is called a penal liability or criminal liability based on the Indian Penal Code, which I have little bit elaborated before. Now, another statute that fixes liability for a doctor is the Consumer Protection Act. It has defined deficiency in service. So if there is any deficiency in service attributed to a doctor, he is liable under Consumer Protection Act. And finally, our parent act, Dentist Act, also fixes liability if there is a misconduct, professional misconduct. So these are the 5 statutes that fix liability to a doctor, out of which the first 4 fixes the civil liability And IPC or Indian Penal Code fixes criminal liability to a doctor. Don't worry too much about it. Just for information's sake, I explained this. Let me elaborate a little bit about on Indian Contract Act and contractual liability. How does contractual liability arises when we are treating patients? Are we entering into a contract or not? Now I will elaborate this. Look at this. You are setting a practice in a public place and putting up a board, dental specialty clinic, whatever. Now this act by you is termed as an offer. Remember, an offer is very essential for a contract. When a patient, this is called a public offer. When a patient visits and comes inside your clinic and be seated outside your operatory, he is impliedly accepting that offer. So acceptance and offer is very essential part of a contract. So he is doing that. Next is when you examine and you discuss the treatment plan with the patient, and when the patient agrees for your treatment plan, remember, a valid contract is established. Even though it is not written one, an implied contract is established between you and the patient. Your duty to care arises from this point onwards. So this is how a contractual liability arises for a doctor. Now, there is one more kind of liability called vicarious liability. The word vicar or vicar, meaning a person who holds some responsibility, a vicar of a parish, a vicar of a temple, etc. Now, an organization is responsible for the mistakes done by its employees. Similarly, a hospital is responsible for the torts. I told you tort, an example is a negligence done by the doctor, nurses, paramedical staff, etc. So we also have, in addition to the statutory liability, we have something called vicarious liability too. This is just to elaborate on some aspects regarding that criminal liabilities. Okay. Now, my final thoughts regarding this case is the statute that will be evoked against a doctor in this situation will be mostly the Indian Penal Code by filing a complaint in the police station, and Consumer Protection Act to get some compensation from the doctor. Now, when a case is filed in the police station, remember there will be an FIR launched. FIR meaning First Information Report. A first information report is a public document. Okay, that will be uploaded in the website also, or you can get a copy from the police station. Suppose if there is severe misrepresentation against a dentist in the FIR, you can approach the High Court and get the FIR quashed. Okay. And the second aspect that you should think is you should always insist on a post-mortem if such an incident, unfortunate incident happens. Now, during that time, definitely the patient party and bystanders will tell you, we don't have any complaint, doctor, so there is no need for post-mortem. Please don't accept this, okay, because post-mortem will prove what could be the exact reason for the death. Now, suppose this patient was not in your dental chair, he might have been walking on the road and he might collapse and die. So, unfortunately for us, he was there inside our operatory. So, we need to prove that the death was not because of our treatment. That is, the direct cause of the death has to be established, for which a post-mortem report is mandatory. Now, of course, you can discuss the matter with a good lawyer, and this case also can be fought out very easily. Let me move on to the third case scenario. This is a very common incident. 22-year-old male patient underwent orthodontic treatment for class 2 with extractions. Later, he claims negligence when he observed there was some relapse. Relapse happens with following orthodontic treatment. The points I wanted to highlight here is the importance of documentation. Now, bit about Consumer Protection Act, because in such kind of events, patient will be directly going to a consumer protection court, and other avenues for redressal for the patient. Now, regarding documentation, again, I need not highlight the importance of documentation. Now, in this case, I call certain documentation as a critical documentation. For example, when you discuss certain events with patient, for example, relapse or post-orthodontic treatment, sometimes the patient will make certain innocent comments that, doctor, I could not use the retainer. After 3 months, I lost the retainer. Some things like that. Or I had to terminate the treatment prematurely because I had to go for marriage or studies and things like that. Or due to irregular follow-up. Now, those are, I would call it as defensive documentation. But remember, you should have documented these things during the course of treatment. Please make sure that don't attempt to tamper charts, because definitely it will come to your mind that if a patient goes to court, see, all the records are with me, I can go and write and add something and all. Remember, don't do that, because the court will be in possession of these records. It will send for handwriting and other kind of analysis. Also, when court discovers that you have tampered chart, court will use a word called estoppel. Estoppel meaning shut your mouth. That means court will openly tell doctor, you shut your mouth because you have tampered the records. Now you don't adduce any more evidence like that. So now what happens in this situation is, suppose you are tampering and you add that patient is irregular and all. Suddenly the patient may be adducing some other evidence in the court that your payment chart or payment card will be given there, where every month the patient has visited you and you have entered money or things like that. So don't try to tamper chart. You should have your documentation in place for every case right from beginning. There's no shortcuts for that. Now, as an orthodontist, I would like to tell, I will be explaining to the patient that tooth keeps shifting its position throughout life. Just because tooth can be moved, orthodontic tooth movement is possible. Also, lifelong retention is the only solution if you want to avoid any relapse at all. Okay. Now, let me come to the next point, Consumer Protection Act. Now, consumer protection, don't think that this is something that is totally against doctors. We are being crucified and all. Remember, it is a social welfare legislation. Even we have brought something or we have availed some service from some other place. If there is a deficiency, we can also approach court. It is a social welfare legislation. Now, the Consumer Protection Act has defined consumers, service, deficiency in services, etc., which I'm not going to elaborate. But in this case, my defense will be something called limitation period. That means a consumer, after availing service or buying a product, has to point out the deficiency and file a complaint within 2 years period. After 2 years, the Consumer Protection Act will not entertain any case. So suppose if the event has occurred after 2 years, then the patient cannot claim negligence against a doctor. And definitely the patient will be approaching a district commission when the claim is below 1 crore rupees. I will come to that a little later. The other avenues for patient redressal will be definitely the Dental Council of India. That is by means of State Dental Council, where they can file a complaint, or in a civil court. Now remember, all these things will not gain much benefit to the patient. They will never usually go, because in civil courts will take years and years to settle a case. Now, before final analysis of this case, I thought I will little bit elaborate on documentation and record keeping. I will not waste much of your time. I will just highlight the very important points. Write this to your heart. Writing saves you. And court believes only on evidence. If not recorded, the court says that it means it is not done. As simple as that. Regarding basic principles of documentation, I will just highlight 2 points. Don't leave any intentional blank space while you are charting or documenting. And while you want to strike off something, don't use whitener. Just strike once and initial it there, or you can mention why the correction was done. And always enter the phone consultations, because during this COVID period, we know that we have delivered a lot of telephonic consultations. Medical Council of India has already published guidelines regarding this remote dentistry, whereas remote medical practice, whereas Dental Council of India is yet to publish exact guidelines, but it is accepted. So you note it down also. 5 elements of effective documentation is the information that you are entering should be factual, There should be timeliness. It should be legibly written and use only standard abbreviations, and the document should be complete. Complete means, suppose if you are giving this document to a second dentist to read without understanding the scenario, while reading that, he or she should understand what exactly this patient has gone through in your clinic. It should be like a cinematographic story writing. That way it should be complete. Then only it will be a complete documentation. You might have heard about medical transcription and all, where the Western world have recognized the importance. Also understand digital documentation is permitted, and tampering of evidence is again punishable under the Information Technology Act. Now, retain the original documents whenever you are releasing the certified copy. And this is very important for medico-legal cases, especially. And you should maintain a certificate register in your practice. Dental Council of India has also mandated storing records for minimum period of 3 years. And upon a request by the patient or by a court or a competent authority, you are bound to release the records within 72 hours. Also note that you take a duplicate copy and save with you and give the original if it is requested by the court. Now, regarding Consumer Protection Act, there is a relaxation for adolescents until the age of 18 years. Now, suppose if the patient has undergone orthodontic treatment at the age of 15 years or 14 years, they can still file a complaint after they have become age of majority, that is 18 years. So you need to store the records of such patients up to 18 years plus another 2 years. That is a limitation period for Consumer Protection Act. That means up to 20 years you need to maintain records of a patient who had undergone treatment to you at the age of, say, 14 years or 13 years. I hope it is very clear. And don't ignore handwriting, because courts have recognized this also. Now, let me ask you this question. Are doctors in or out of the Consumer Protection Act? You can use your chat box and reply. Yes means if doctors are in, and no means if doctors are out of the Consumer Protection Act 2019. Let me just find whether you are there or not. You can use your chat box to give the response. Yes, I am getting responses. Yes, that means everybody is of the view that doctors are in. That means the Consumer Protection Act is applicable for doctors. Thank you. Thank you for your response. Let us proceed. Okay. Doctors and treatment were never included in the Consumer Protection Act 1986 and in 2019. Okay, expressly, doctor and doctor services were not included in the Consumer Protection, the old act as well as the new act. But this was included later by a judicial decision in a case called IMA versus VP Shanda in 1995. You may be aware of all those things. Now, recently there was a big hue and cry whether doctors are in or out of the new act, 2019 act. The old act was repealed and the new act is in force now. This is because in the draft bill of this new act, the doctors were expressly included in the act, unlike the old act where nothing was mentioned about treatment. In the new act, when the draft bill was introduced, medical service was defined and included in the act. Then there was a big protest by the doctors, and finally it was excluded. And the real other reason was, at that time the government did not have majority in Rajya Sabha. So passing the bill in Rajya Sabha was a hurdle, and hence it was excluded. That means medical profession definition is not included in the new act. That doesn't mean that doctors are out of the act, because doctors are still in, because previously also it was included by a judicial decision. Correct. Now, 2-3 points that I thought I will note the difference between new act and old act is that there is a provision called mediation in the new act. Previously, suppose if a patient files a complaint, if you want to negotiate, what you used to do or we used to do is we used to negotiate it outside the court. But here, act itself provides a mechanism for mediation. That means the court will ask you whether you want to mediate. Now, suppose if the parties agree, the court will proclaim it as a verdict so that the patient cannot file a case again later. And another point about the new act is that there is a change in the pecuniary jurisdiction. That means up to 1 crore is now filed in the district commission. I will elaborate little later. And there is another provision for misleading advertisements can be curbed. Recently, you might have heard about one Malayalam actor was fined for false claim in advertisements. And finally, e-filing and video conferencing is allowed as per the new act. That means the consumer need not go to court even. Now, there is a 3-tier mechanism. District commission, if the claimed amount is less than 1 crore, 1 to 10 crore state commission, national commission if it is above 10 crore. So generally the patient or a consumer will be filing complaint in the district commission. And the question is, under which district? The district where the complainant or the opposite party resides. And how the complaint is given. It is by a written application with an affidavit with all the proofs and a meager court fees. Lawyer is not compulsory. E-filing and e-hearing are allowed. Every district commission will have 1 president and 2 members. And in each sittings, there should be at least 2 members. And what will happen to a consumer's complaint? This will be either accepted or rejected. Now, if it is rejected, the consumer forum will give you an opportunity to be heard. And if it is accepted, it will serve notice to the opposite party. Now, just imagine here a patient is filing a complaint against doctor. That means the doctor will be the opposite party. So once that the patient's complaint is accepted, within 21 days, the notice will be served to the doctor. Now, what should the opposite party do? The opposite party can accept. Now, accepted means then there is no case. You will have to give the compensation. But usually, we as dentist will reject the claim. Then when we reject the claim, what should we do? We should give an explanation within 13 days, in 30 days. And if you apply to the court, we will get another 15 days extension. So that is how a complaint is filed and what we should do when we get a legal notice. Also, always think of mediation possibility. Now, how cases are decided in a consumer court? It is based on the explanations that you give and the proofs that you submit along with the application. Also, the court may call for expert witness, which I have appeared once or twice before court. And the decision will occur within 3 months. And if there is any lab investigation required, it will take another 5 months. That is why consumer court is more popular, because you get a decision very fast. Remember, the consumer court is publicly very much acceptable because of the simple steps, e-filing, low court fees, rapid remedy, and high compensation. Now, suppose if we are aggrieved with the decision, we can go for appeals. From a district commission, we can file an appeal in the state commission within 45 days. But there is a clause that if the district commission fixes a compensation, 50% of that should be deposited before we go to the state commission. And appeal from state commission lies in the national commission, for which again we have another 30 days. And finally, from national commission, it can go to Supreme Court. There again, we have another 30 days time. Don't get tensed, don't get worried about this, because I just wanted to sensitize you regarding this consumer protection court and activities. That's all. Remember, only 15% of medical negligence cases are genuine. And we often get verdicts like this, consumer court dismisses negligence complaint against dentist. Don't worry about it. My final thoughts regarding this case, I will defend this case by stating of limitation period, which I have highlighted already. Now, my defensive documentation will come to my help provided I have done it properly. And I will definitely adduce contributory negligence from patient side also when my defensive documentation is to that extent. Of course, like for example, patients did not wear retainer, did not report immediately when the retainer was lost, did not report to you when they first observed a relapse or premature termination. All those things will fix liability to the patient also, and that is termed as contributory negligence. During this COVID time, many a times patients could not come and we could not see. So that is also called as an act of God or vis major in legal terms. So that is also fixes contributory negligence, or that will help us to evade from the liability. Now, friends, let us have a small screen break for some time. Meanwhile, if you have any query, you can type it in the chat box. Let's go ahead, friends, with the fourth case scenario. Now here, a 35-year-old female patient developed pain following RCT and went to another clinic where the doctor told this teeth cannot be saved and it is indicated for extraction, and underwent extraction there. Later, husband wants refund. This has happened very recently, and I know the doctor has settled it by giving a refund amount. Now, the points that I thought of discussing here is the importance of individualized informed consent form, due care or proper care and instructions, communication skills, duty of the dentist to one another, and a bit about deep pocket theory, which I have already elaborated. Remember, court over the few years have proclaimed many times that blanket consent form is not adequate or not enough. That means you have to have an individualized consent form for each patient, because you might be thinking when administering a consent form is that you somehow need a signature, but court will be evaluating that this consent form has given to a patient after elaborating all the points, and the patient understood everything and agreed to the treatment, and that is how the consent is obtained. So make sure you have a individualized consent form. Now, in this case, possibility of pain and even the teeth need to be, the need for extraction has to be explained. There should be a mechanism to attend emergency in your practice, because pain is considered as a dental emergency because its perception varies. Now, regarding communication skill and duty of care Adverse comments initiate more than 95% of adverse comments initiate more than 90. I am getting some messages in between. Sorry for that. Adverse comments initiate more than 95% of the litigation. This is, remember, when you pass an adverse comment, this is applicable for you also. Don't let you regret after passing an adverse comment. There is a dentist have a duty bound to mutually respect each other. I'm getting a message in between. I'm sorry for it. Now, in this case, I told you the case was settled by paying the amount back. But my take is, don't directly pay the amount back. You can, suppose if this such of incidents occurs, you can always agree to pay, or you can tell that I will discuss the matter with my endodontist and let you know. Then they'll be happy for a while. When they come back, you can tell, okay, my endodontist agreed for a refund. They will be happy, but again, don't better give, because this patient is not a good patient for you. So you need not retain that patient, but you can always have a cost involved in the treatment, which could be reduced, and always you enter into an agreement between the patient and try to get it written in a stamp paper, a 50 rupee stamp paper, and then only give the money back, if at all you are giving it back. Now, some points I wanted to discuss regarding this case is regarding informed consent. Remember, the era of paternalism is over. Courts have started recognizing the need for informed consent, and various judicial decisions have come. Remember, the protection of your implied consent ends with the basic dental examination. At least few of you may remember this gentleman. Now, he is none other than Raman Lamba. He was a very brave gentleman. He was standing very close to the crease while batting. I think some auto play has enabled or something. Dr. Joe, are you there?
I'm here, sir.
Some auto play has enabled. It is slides are moving. I think right now it is okay.
Okay, sir.
Okay. Now this gentleman was standing very close to the batsman, and he got hit by the ball, and he was admitted in a hospital, and within few days he passed away. Now my question is, can Raman Lamba or his parents or his relatives claim negligence against the doctor? Obviously, the answer will be no, because he has consented for taking part in the game, and he was standing over there, and he was getting hit. The legal maxim here is called volundi non fit injuria, which simply means that if you have consented, you cannot complain later. Now, this is the exact principle that is applicable for us dentists also. If patients have given a true consent to us, later they cannot complain. Now, even then the patient will go to court. That is different, but your lawyer can easily defend it. The ingredients of consent, I know you are aware of it. I'm not elaborate it in detail. Voluntary, it should be competent. If a child between 12 to 18 years is giving consent, there should be something else called accent also. Accent simply means a written acceptance from the child. And it should be informed. Informed means you should have been giving all the informations to the patient before getting the signature, because your Google doctor will be there for the patient, which will give all the informations, right or wrong, if you are not giving proper informations. And it should be obtained prior to the start of treatment. Also remember, most importantly, you need specific consent for each procedure. Now, this is held in various judicial decisions. Blanket consent not valid. Fresh consent for a repeat procedure. If you are doing a repeat RCT or re-RCT or re-orthodontic treatment, remember you need a repeat consent. And for anesthesia and surgery, you need separate consent. For example, in case of orthognathic surgery, we need separate consent for anesthesia as well as surgery. And obviously, the patient has to put their signature in the consent form, and doctor also should sign it. Now, here I have taken an example of root canal treatment. Now, root canal treatment and extractions are considered to be the most situation where negligence claims have been claimed by patients. For a root canal treatment, you need to explain how it is done. For example, if possible, demonstrate with photos and models. What if the RCT is not done? That is the due course. If RCT is not done, what will happen? How many sittings and how many duration per sitting, etc., should be explained to the patient. Anticipated complications, how to handle it. For example, breakage of instrument, need for crown is something which we never explain to the patient. That is very much important. And cost of the crown, cost of the treatment, etc., need to be explained to the patient. And dated signature is mandatory. Now, this is a model informed consent form for root canal treatment. This is available in the net. This is a blanket consent form. We have to customize this. Let us see how can we customize this. For example, here it is mentioned about there is no guarantee, possible hidden problems. Everything has been explained there. Future issues, including the need for extraction, have been elaborated there. Risk have been mentioned. Other treatment options have been explained. Need for the crown has been elaborated. And finally, it has stated that the patient, or I have understood everything and about the explanation, and I am willingly give my signature. And finally, the dated signature. So technically, this will form or serve you only as an information sheet because this is a blanket form. Now, you can also add other informations like LA complications, need for X-rays, etc. Also, that happens along with root canal treatment. Now, how do you customize this? You can customize this by adding a blank space for case-specific information where you can write with your pen whatever needed. Now, suppose if you are using a digital media, there is something called blank smart consent where you can type and you can save that. Your informed consent form will be put into test in a court. And if patient says before a judge that if I had known this before, I wouldn't have opted for RCT. That means your consent for process has been flawed. Now, don't worry too much about that. You use a standard form and customize it and use it. But if you have at least that, remember, your lawyer can defend a case very easily in a court of law. Now, being an orthodontist, if I am subjecting a patient to orthodontic treatment, I will explain to them that this is a cosmetic treatment. There is need for extractions. There may be chance for the extraction space to reopen. Duration of treatment and importance of regular follow-up will be explained. Breakages, hygienes, cost of treatment, risks involved like white spot lesions, root resorptions, TMD pains, the use of retainer, and if you don't use it, what will happen? All those things will be elaborated to them. And I will always say, I will never give guarantee to any form of treatment. And I will tell to the patient that I am reducing a bigger problem to a smaller problem. And you should wear retainer as long as you want to maintain the results. That is a safe way of handling it. But friends, I know there are some roadblocks to consent process. This is a time-consuming process. You need to keep explaining to every patient, clearing their doubt, alternate treatment plans, expected complications. One patient, two patients, it's okay. If it is a busy running clinic, it will be a very tedious process. You also may think that what will the patient think? Whether the patient will think that I am not competent enough, or shall the patient may think that shall I look for a different doctor? All those things are thoughts that go into your mind when you are introducing consent process in the practice. And also you might think, are my neighboring practitioners taking this? Will I lose my clients because of this? Remember, it is difficult to initiate and implement all of a sudden, but Patient also may think, till yesterday this process was not there, then why suddenly? You will have to overcome this. To overcome this, what points that I thought were like, this should be made aware in the public media and social media and by specialty associations. And this should be implemented as routine part under UG training in dental practice. And it should be made mandatory in all teaching institutions, and even senior practitioners should initiate, because they may not mind or bother about losing 1 or 2 patients. And this process of consent can be initiated at your reception desk without taxing your time. You can delegate this to your receptionist also, and you need to explain only the specific area in your consent form. And if everybody practices this with a board inside your clinic, no consent, no treatment, then it will be well accepted. And remember, to me, this is the ideal time for initiating if you have not started it, because right now this COVID-19 related screening process, and you are giving so many flyers to them and signatures, writing their phone numbers, everything. So this is the best time to initiate consent process if you have not done. Please initiate as a regular process or a standard consent form. Later you can think of refining it. Now, this is a girl who came for orthodontic treatment to me. As you see, this is a bimaxillary protrusion. I decided to go ahead with all first premolar extraction and reinforced anchorage with mini implants. I placed implant on the left side, there was no issue, but in the right side, when I placed implant, the implant got fractured. A piece was inside the bone. I had not explained to the patient regarding the possibility of a implant fracture or mini implant fracture, what to do. Luckily for me, the patients were understanding. I offered them that it could be removed, but it requires a surgical procedure, trephination, and all those things have been done. There will be no problem when a piece remains inside, and they luckily agreed to it. But remember, I should have explained the possibility of an implant fracture before placing it. This can occur in any form of treatment. Remember, obtaining consent prior is informed consent, whereas obtaining consent later, as in this case, is a mere excuse. Now, regarding communication skills, I need not elaborate. Most of the time, our communication skills are unilateral, and most litigations are as part of adverse comments made by a fellow dentist. Every good conversation starts with good listening. Barriers to good communication are poor listening skills, inappropriate assumptions about patients. This is very important. Okay, patients may not look very much educated, but you don't assume them unnecessarily in a wrong way. Inappropriate language and prejudice. Most complaints that we hear are doctors did not listen me, did not hear me. He did not listen to my complaints. He did not explain about the procedure. If I had known this before, I wouldn't have undergone this treatment. The cost was not explained to me. I didn't know that this treatment takes this much long, because many times after initiating orthodontic treatment, the 3rd month, the patient starts asking, when can I get it debonded? When can I get it debonded? How long it will take? We might have already explained to them also, because patient might have undergone little painful period. So they are frustrated. So we have to understand, we have to be empathetic, and we have to sit down and again explain to them regarding the importance of it. And finally, because of lack of explanation, patients will get a feeling that doctor is hiding something from them. So that feeling should not happen. And my final thoughts regarding this particular case is, this case, the aspiration of the endodontic instrument should have been totally avoidable. Now, this case number 4, where pain following orthodontic treatment, that should have been totally avoidable, because the doctor should have attended pain in their own clinic. Now, you need not agree immediately regarding refund of the case on the spot. And if refunded, make sure you get into an agreement, and so that the patient will not go to court further and ask for a amount. And defending this case is not very difficult, but not very easy by both the parties, because for dentist, Definitely, you could not manage pain effectively when the patient reported back. That could be one reason. Now, another, from patient side also, patient has gone to another dentist and got the extraction done. That will be my legal point. I will tell that, see, I was not available for attending the pain. That is fine. That is human error. That is okay. But if the patient had come to me, I would have managed pain and I would have saved the tooth. That will be my view. So contributory negligence can be adduced from a legal point of view. So this is not very easily defendable, but not at all difficult also. Let me come to my final case. During endodontic procedure, the endodontic file slips into the throat and patient aspirates it. And it goes to the lungs, and patient was transferred to the hospital, and it was retrieved using an endoscopic procedure, and patient later claims negligence. Now, this instance I mentioned, it has happened in the institution where I am working, and I am aware of it. Here, the points that I wanted to discuss is regarding the proper standard of care and ingredients of negligence. Now, for an RCT, rubber dam is the standard of care. That when it was not done, you cannot escape from the liability. Now, I have seen one of my friend doctor tying thread in each file and using it as a protective mechanism. Now, when the patient has aspirated, you should position the patient in a left lateral position so that it will not directly enter into the right lung, etc. So all these are standard of care that you should possess while doing the procedure or while an emergency situation has happened. That time also, what all standard of care that you should perform should have been done. Remember, the court expects only basic skills to perform a basic procedure. That simply means that court expect enhanced skill to perform an enhanced or a specialty procedure. That is also understandable. Now, how a case is decided is based on something called Bolam test. This is also called as ordinary prudent clinician test. What a responsible dentist would have done in a similar situation will be assessed by the court, and if your act is in line with that act, you will escape from the liability. But there is another school of thought which says that this Bolam test is outdated, and there is another test called Bolito test, which is a patient-friendly test where the doctor should analyze their mind and think and weigh between the risk and benefit and act in that situation. But that type of testing in court has not become so rampant. The next point regarding this case I will be discussing is ingredients of negligence and how a case is proved in a court of law. The ingredients of negligence are termed as 4D. There are 4 Ds. The first one is duty to care. That is, when you are the patient is under your care, you are duty bound to treat the patient. Second one is dereliction of duty. That means there is a poor standard of care or some dereliction has happened from your side. Third one is damage. Damage may be a physical or a mental damage or injury. And fourth point is directly related. That is directness of the cause. That is the injury should be directly related to your treatment. So these are the 4 Ds of negligence. A patient or a patient lawyer will be trying to prove this, and a chain reaction of all 4s are proved in a court, then only the doctor will be liable. So the doctor's lawyer will be trying to break this chain. There are 2 weak links in this chain. I will point out that the 2 weak links in this chain are dereliction of duty and direct cause. So a dentist lawyer will be breaking this second D and the 4th D. That is, the doctor will claim, or the lawyer will claim that my client has done all standard things as per the requirements, and he tries to prove that. Then secondly, he will tell this injury is not directly related to my doctor's cause of action. So that is how a case is being proved in a court of law. Now, negligence is not limited to India alone. 1 lakh patients die in USA out of medical negligence. You might remember this picture. Our late favorite actress Sridevi's mother was operated on the wrong side, not in India, in USA. of the brain. In UK, it is considered as the third most frequent reason for death. And fortunately in India, we don't have exact claims, but it is close to 1 lakh. Negligence technically falls in two categories. One is the act of commission, meaning somebody is doing something which is under standard or not up to the right standard. So there is act of commission. Whereas another category is act of omission. You are omitting to do something which you should have done. For example, a test dose before administering LA in a new patient. So that is something you should have done and you are not doing. So that is act of omission. Now, this girl again was under my treatment. So she was a mild crowding malocclusion with an impacted canine on the upper left quadrant. So my treatment plan was to go for all first premolar extraction, second premolar extractions, and first premolar on the upper left quadrant because canine was impacted. So I had sent for the examination. Next day when I went for, this was during my diagnosis period, and next time when I was doing the bonding, I got the patient with all 5 extracted. So this is sheer negligence. This amounts to something called defined under Indian Penal Code as a grievous hurt, like amputating a wrong leg. This is equated by court analogously like that. Okay, amputating of a wrong leg because tooth is considered as an organ by the court. So this is a grievous hurt, and this can evoke criminal liability on the doctor. Now, in this case, I can easily manage the case without informing the patient also. But technically, we are supposed to inform and elaborate on the patient and all those things. That is a technical side of it. I'm not elaborating much on that. Due care is the only word that could be exercised over here. This boy is a Malayali boy who had undergone surgery for genioplasty, and unfortunately, he passed away. Doctors were accused with negligence. And to my knowledge, thrice police officers has come to my institution for before asking whether the doctor can be arrested or not, complying to Jacob Matthew versus State of Punjab case law to fix negligence against the doctor. But remember, death under anesthesia can happen when the patient is undergoing general anesthesia. So much of incidents we are aware of it happening around. So if I am to analyze my final case from the final points, like this case cannot be successfully defended in a court of law because there is a legal maxim. This is a Latin maxim which says that res ipsa locutor, which meaning the thing speaks for itself. For example, if a gauze piece is left inside a person's abdomen during surgery, and if it is recovered by another doctor, then the court will stop. The court will ask the doctor's lawyer to shut your mouth because the thing speaks for itself. Here, retrieving a file from the throat will speak for itself. The court will fix prima facie liability on the doctor, and my suggestion would be a settlement would be ideal, out of the court settlement. So my case scenarios were 5 cases I presented. First 3 cases, I would say, if you have proper documentation, it is easy to defend. Don't worry about it. 4th case is like, I would say 50-50. And 5th case, better go ahead with settling this case. Obviously, I come to my last part of the presentation. Prevention is better than cure. One satisfied customer may or may not bring you a new case, but one unsatisfied customer will turn down at least 10 customers. So if I am asked to name a model practitioner, the qualities of a model practitioner, I would say he should be qualified and licensed. He should possess adequate skill and knowledge. He should select patients judiciously for treatment. This is very important. Now, sometimes I have seen 2 kinds of practice. One is bulk practice, where everybody is their patient. And the another one is judiciously selecting patients. But I have seen at the end, the revenue of both the clinic will be almost the same. But when you are accepting all the cases to you, remember, a potentially litigant patient also been accepted as a patient in your clinic, which he would have been otherwise in your neighbor's practice, that also you have invited to your clinic. So be very careful in selecting patients. When you talk to them, you understand their perception and accordingly proceed. Take proper case history and document everything, and make patients participate in the informed decision-making process, and deliver accepted standard of care to every patient. And a model practitioner will effectively communicate to each category of patients. Imagine you are a 40-year-old dentist. You will be having child from 2 years, 3 years up to senior citizen at the age of 80, 85 years. So you will be interacting with each category of patients. So you need to have the skill to deal with all category of patients in your practice, to encircle, to engage them. Your patient may be very much looking innocent, understands everything, receives everything, very cooperative during treatment, but you may not know at what point of time the patient turns out to have a different personality. So the only solution is to take universal precaution. Now, in an unfortunate event of litigation, what should you do? From a legal standpoint of view, I must say, don't be panic. You sit down, recollect all the events, involve your paramedics and try to recollect all the things, write down those things in a chronological order, retrieve all the records, including a recall history, maybe mobile messages, x-rays, lab test, etc. Recover CCTV footage or whatever if possible. You can also think of negotiating with the patient or the patient party or with their lawyer if needed. Anyway, that based on the situation. You can also have a policy like, waiving off the remaining bill. These policies are there in abroad, okay? And undertake further treatment at a concession rate, etc. Those are some policies that you can accept. And finally, you should definitely approach a lawyer, present your case, and proceed accordingly. So don't be too panic. And don't get into argument with patients and patient party. Okay, control your paramedics' behavior also with the patients. Please don't issue any records without adequate backup. Issue notes or receipt from the patient should be obtained when you are issuing some records to the patient. Now, finally, let us see some points regarding selection of a lawyer. This is something which is very crucial. My suggestion would be not to select a lawyer who is a close friend of you just because he is being a lawyer or a family friend. If he is experienced in a consumer case or a case in which the filing has been done, then of course you can go ahead. A trusted lawyer with a consumer case would be ideal, and you should need to reply within 30 days or within extended period of 45 days. Also be part of the professional indemnity schemes instituted by professional bodies, and associations also will have their panel of lawyers, which will definitely help you out. So you need not worry at all, provided you are doing standard of care, your standard of care is at par. The bench also matters. The bench means the judge. A good lawyer knows the law and a great lawyer knows the judge. Because sometimes this consumer forum judges, okay, there may be president and other members. The other members may not be lawyers as such, okay. They might have a bad experience with a dental clinic or something. So all those things will come. Definitely you can go to appeal and you can get it out, because the bench also matters in a consumer case. That is a point that I wanted to tell. So my take-home messages from this case-based analysis are, we have to be professional and follow the code of conduct. We have to practice according to the law of land. There are 40+ laws to be obeyed by a practitioner in India. Remember, law is an instrument which offers protection to all, not only for one class of people. And finally, the armors of protection are good communication skills, documentation, and proper informed consent. So friends, practice dentistry with exercising due care, enhance your skills, and be empathetic. Thank you. That's all, Your Honor. And I rest my case for discussion. Thank you. Thank you very much for your patient hearing.
Thank you, sir. Thank you so much. Now we know that we all need to know all of this. The more we know, the more we practice, the more we secure ourselves for the future. So we already have a few questions here in the chat box. Shall we go ahead?
Sure.
The first question, while it was a question in the session, was, is it legal to have a CCTV in the operatory? As I believe we can have it in the waiting room, consultation room, but not in the treatment room.
You can have it in the CCTV, also in the operatory, provided two things you have to look. One, you have to display a board that this clinic is under CCTV surveillance or you are under CCTV footage. So that document has to be placed there. Then you should not unnecessarily circulate the recordings inside the clinic. That should be stored only for your personal use and protection. That responsibility the dentist should take. That's all.
Thank you so much, sir. The next question is, what is blanket consent?
Blanket consent. Blanket
Yes.
consent is commercially available consent forms in the net, or a blanket consent that you make that, you know, I agree to the treatment, whatever that the doctor has explained, something like that. Individualized consent means it should be separate for RCT, separate for orthodontic treatment, separate for extraction, separate for minor surgery, etc. And in that consent itself, there should be an option for individualization. That means that patient will be unique, maybe having some medical problems or some other issues, allergic to drugs and all those things. So because the patient is allergic to penicillin, I am using erythromycin. Such matter should be mentioned in your chart, as well as it should be noted down in the consent form. Some, you know, just elaborated one point. So it should be individualized. And blanket means, you know, like you are circulating one same format for every patient. That's all. Thank you.
Thank you, sir. This question that is coming up is for the case 3 that you discussed. The question is the 2-year gap of claim is after debonding the braces or at the start of the treatment?
After the completion of the treatment. Now, at the completion of the treatment only will finish your responsibility in doing the treatment. Okay. So when you have debonded and put the patient on retainer, your legal responsibility as part of that treatment ends over there. From that point onwards, 2 years is the limitation period, and sometimes court may condone delay. Condone delay means court can extend some further period also. That definitely our lawyer will be able to take care. So 2 years is the limitation period. I thank you for this question.
Thank you so much, sir. The next question is it legal to perform facial cosmetics procedures by dentists?
Yeah, that is a very good question. That depends on, it should come under your area of specialization. You should be trained for that. So if you are really trained, you are acquiring some recognized course and you are getting trained in that, then you should be able to do that. Otherwise, there is no clear-cut laws or guidelines regarding that. You should be trained, adequately trained, and in an event of litigation, you should be able to prove that I am trained in this. That's it. Thank you.
Thank you, sir. The next question is, for treatments under general anesthesia, what is dentist's liability?
Yeah. Now, in treating under general anesthesia, there are at least 2 persons involved. One is an anesthetist, other will be a dentist who is treating. So there will be liability for anesthetist as well as the dentist. This is termed in legal words as joint and several liability. Joint liability means court can fix liability together because this is a team approach. One person cannot totally escape from the liability. Stating that this is not my job, but because eventually the treatment is done for one patient. So joint and several liability means both the parties who have involved in treatment will be fixed liability based on the negligence claim or whatever that arises. So the dentist also will be partly liable, and the court will fix a quantum of liability based on that person's involvement in the negligent act.
Thank you, sir. Sir, the next question is accidental swallowing of file during the procedure. In which category does it fall?
Yeah, accidental swallowing of file. Suppose if it is, for example, the standard of care is not followed. For example, in a molar RCT, if you are not having a rubber dam being in place, that is the accepted standard of care. So if that is not there, definitely there will be liability, because we know that as we move posteriorly, especially posterior part of the tongue supplied by vagus nerve, when it gets stimulated, the immediate response is swallowing. So patient might swallow. So that swallowing an instrument is definitely a doctor's liability, because file is to be seen inside mouth, but inside stomach or lungs is not the ordinary place where a file has to be. So by whatever means it is swallowed, the doctor will be liable. Definitely it is by an accident or things can be claimed, but definitely there will be some amount of liability fixed on the doctor, especially when standard of care is not there. But suppose if irrespective of taking precautions like rubber dam or hanging a thread and things like that, then you can evade from it. Thank you.
Thank you, sir. The next question from the same doctor we have is, any regulations from the law for display of degrees of doctors, radiation and biomedical waste in clinics?
Now, degrees, there is code of conduct or dentist act itself has prescribed what all things you can display and what all things you cannot display as your name board. That the idea is basically very simple, that you should not misrepresent the patient or misdirect the patient. Patient should not get an idea that because of so much or so that kind of degrees, this person is better than that person or something like that. So that is the idea. Regarding radiation and all, there is some regulation that the clinic should be, your radiological equipment should be evaluated and license should be obtained, and display of such license is your choice. You need not, because if at all the authority comes for inspection, you can simply show the license of your radiation and other things. That is your choice.
Thank you, sir. The next question is, how to report child abuse when we notice it? Can it backfire if the parent files a case against us for false accusation?
Yeah, that is a sensitive issue. Now, child abuse in the sense happening in the clinic will be reported by patient or somebody else. But if you note some unusual injury on the face or on the body, that amounts to child abuse. There are specific laws for all those things, and you are duty bound to inform to the police station. Now, that again, a sensitive issue. You need to discuss the matter with the parent or the guardian. Now, suppose if parents also might not have been aware of this, definitely they will cooperate with you or they will take, but with their consent, it will be much easier. But the law states that if you have noted, you are duty bound to inform. Law is actually something like black and white. No, the persons who are applying law should apply with mindfully. Law technically says that if you notice that, you are duty bound to inform, but that is it's a delicate issue that you have to handle out on a case-based analysis. But if you go out of that, and then it can backfire also. Now, that is something which we have to think about it and discuss with a lawyer based on the situation, or a respectable person based on the situation, and better decide accordingly at that time, rather than acting impulsively.
Thank you, sir. The next question is, in case of file getting aspirated, why left lateral position is suggested?
Yeah, I think that is because of your trachea is getting bifurcated and the right side is more prone, because your right tracheal bifurcation is more at an obtuse angle. So there is more chance of it getting into the lungs. But if it is in the trachea, it is easy to retrieve using a bronchoscope. So it is better that it should not enter into the lungs. That is why. So that is applicable for any foreign body that is being aspirated. Not only for file, I guess.
Yes, sir. Thank you, sir. One more question about the aspiration is, what if a patient swallows a RPE screw, rapid palatal expansion screw, while turning at home?
Yeah, that is again a very good question. Now,
So the question is from Bhima Sarvanshi.
yeah, there is here again, I would say, first is prevention. We have threads tying to the activation screw, which is turned against our finger. Then there is a screw which is right now given with a handle, so that could be held so that it will not. So that precaution has to be taken. Don't give this. Sorry. Don't give this turning key alone, small piece of key alone to the patient or the parent to do. If proper threading and handle is there, definitely your liability ends there. You have to educate them. You have to teach them how the patient should be seated and turn it properly, and adequate care to be taken. In spite of that, if they aspirate it, it is their care. It is their problem, because it is a contributory negligence, or not even contributory. It is their act, because it is being done at their own place, and you have adequately given instructions to them. Now, the important thing from your side is, you should be charting in your chart stating that rapid maxillary expansion screw has been delivered. Patient is instructed to turn the screw once in or twice in a week in whichever direction, by trying the thread to the finger and holding it, or holding it tightly in this and this position, and all instructions have been given. That should be noted in your chart. That will evade or escape you, make you free from your liability when it is done at patient at home. Thank you.
Thank you, sir. The next question is, in the case of dislodged crown after a few years of fixation, is it liable?
Again, here, your limitation period, 2 years will hold. Then dislodgement can be due to, several reasons. You are not giving any guarantee that this crown will never come out. So right from beginning, we are not playing God. No, we cannot give any guarantee that this crown will not come out. Now, when it is coming out, we have to handle it empathetically. Like, we have to re-cement it. Maybe we can waive off the cost if it is immediately, or after several years, like, if it is coming out, still you can charge also. And negligence cannot be attributed merely by the crown that is getting dislodged and all, or coming out, because we are not giving them any guarantee or assurance that it will not come out. We have to handle it carefully. That's it.
Thank you, sir. The next question is, if a patient reports trauma due to domestic violence, can we take up such cases directly, or is there any legal procedure to be followed before proceeding further?
Yeah, the legal proceeding is that patient is brought to your clinic, you observe something, you have to discuss with the parents, and you have to tell them that I am duty bound to inform to the police station regarding this. This falls under medico-legal category. That is the legal stand. You have to duty bound inform to the police station regarding this case. They may say something like, they don't want, they will go away or something. That is their choice, but you have to inform them before starting treatment. If you find there is a abuse, or there is kind of injury or something, you have to inform. But also remember one thing: suppose if it is a road traffic accident or something, pain, bleeding, all those things are emergency. You, without looking anything or without taking any precaution, you are supposed to handle that. If there is a bleeding, you are supposed to arrest it. If there is pain, you are supposed to manage. If there is any foreign body, retrieving all those things, you are supposed to do that without any delay. That is your part of initial care, for which law is always there to protect. After that, you are duty bound to inform and report to the police station, and you have to maintain a wound register in your clinic and enter it, the size of the wound, all those things also.
Thank you, sir. We have one more question from the YouTube, question by Dr. Neha Taneja. The question is, can we put our advertisements on our clinic's website or Google Ads, sir?
Yeah, this is a very good, tricky question, and a very good question. Now, regarding advertisements, the Dental Council has got certain norms. It has prescribed in the Code of Conduct 2014 that you can advertise initially few times when you're opening a clinic. Then if you are changing your practice, if you have possessed some new equipment, if some new doctors join your clinic. So those are the occasions in which you can advertise. So on that occasions, you can advertise, but it is not prudent to keep on advertising continuously in social media. That is not very prudent and not a welcome move. There may be some actions that could be that could lie against you if somebody complains. But there are occasions in which it is permitted legally, and that could be done.
Thank you, sir. The next question is, who is responsible for drug allergies, dentist or drug supplier?
Drug supplier, how can they be responsible? Because drug has got, Indian Pharmacopoeia is giving a drug after its research by permitted under Drugs and Cosmetic Act 1940. So once it is in the market, the supplier is not liable because its allergy and all those things are established by various studies and put it into market. Now you know that whichever drugs are allergic and whichever drugs cannot create allergy. And it is our duty to ensure that the drug is not allergic to that patient by taking a proper history. If proper history is not possible, you can do an allergy test if it is an injectable local anesthesia kind of thing. Otherwise, for example, even paracetamol can be allergic to patient. So if the patient is not aware, you can always ask the patient to take a piece of it and look and observe for some time. And if an allergy is happening after all precautions, it is not your fault, definitely not your fault. What court will look is whether you have been taking all precautions or not. That is considered as an accident, that for which the doctor is not at all liable. But if adequate precautions are not taken, then only we have a claim. I mean, patients have a claim. Otherwise, we are not at all liable if it is happening as an accident.
Thank you, sir. The next question is very interesting, and I think we all have encountered that. The question is, I have seen a number of quack practicing in the busiest areas of the city in northern parts of the India. Why and how any legal actions are not being taken against them? Yes,
actually that slide was there in my presentation, and due to time lag only, I had removed that along with the professionalism when I was mentioned. There has been a study which says that there are more than 3,000 quacks practicing in and around Delhi. Something like that. It is an old article, so number might have changed. Now, in the Dentist Act 2000 for Code of Conduct 2014, it has clearly mentioned that it is a duty of a dentist to report to the concerned authority that if an unauthorized person is practicing, and the Dental Council of India is supposed to take an action. So if somebody is practicing without license, without permission from the Dental Council of India, definitely it is an offense and it has to be brought to the police, and there is an action to be taken against them. And why it is not taken is because of the loopholes in our legal administration mechanism. And it is our duty also to bring it to the notice. If we are silent in this will still continue. So it is the duty bound by the Dental Council of India to take duty, and we are supposed to report to them. Thank you for this question.
Thank you, sir. The next questions have already been answered by you about swallowing. Like a lot of questions about swallowing, sir.
Yeah, regarding swallowing also, like if it totally happens as an accident, then our liability will not be there. But still, again, when that thing is being recovered from something else, the court will apply the legal maxim res ipsa locutor. That means the thing speaks for itself. So we need to defend. Now that is a legal battle to fight out, but to be fought out. But if it really happens as an accident, in spite of taking precaution, definitely we will not be liable. Don't worry about that.
Thank you, sir. This was indeed a wonderful session that we all needed to know. Well, I hope the candidates have enjoyed and also taken a lot of knowledge from this session. I think it's time to wind it up. So thank you all for all the support that you all have given to us. And thank you, sir, for choosing us as a host once again.
Thank
you. So ladies and gentlemen, good night. Till next time.